Good morning, everyone, and thank you for joining us today in our very first ECA Business Fridays webinar. This morning, we are going to be talking all about collateral warranties, what they are, and a guide to the key risks and considerations for subcontractors. Your presenters today are Rob Driscoll, on screen now, Director of Legal and Business here at the ECA, and Obaid Bin-Nasir, Legal and Commercial Advisor at the ECA as well. Without further ado, I will before I hand over to Rob and Obaid, I would just like to mention that at any time during today's presentation, do make use of the questions function. There should be a little question mark in a bubble up on your screen now. Ask your questions at any point and we will get to those at the end of the presentation. Make sure to check out the ECA Members area that you log in with your member number, username and password, and check out all of the resources there for business resilience, as well as all other aspects of electrotechnical contracting, technical business support, HR, all sorts. That's enough from me. I will now hand over to Rob to kick off the presentation. Over to you, Rob.
Thank you, Omar. As Omar said, my name is Rob Driscoll. I run the legal and commercial team at ECA. What we primarily do is field the inquiries of ECA members on various documents, construction issues, disputes, and try and help you out of the various sticky situations in a confidential way, with giving you the least possible bruises, hopefully, along the way. And my colleague, Obaid.
Hi, morning, everyone. My name's Obaid Bin-Nasir. I am a construction solicitor and I work alongside Rob in legal. Between us, we've probably got over 25 to 30 years of experience in the industry. So just to echo what Rob has said, is we like to bring all of this experience to our ECA members, and hopefully today's workshop will assist you in moving forward with your projects, because collateral warranties are one of those topics which you've probably heard the name and you may have dealt with a few, but you may not always necessarily know what exactly they are, why they exist, and what exactly they entail. So hopefully the next hour or so will be a bit of a 101 in terms of what they are, what you should look out for, and ultimately what you can do to put yourself in the best position possible on a project where you've been asked to sign one. Right, so I'm just going to very briefly cover the contents of this presentation. As I've just alluded to, what we are going to cover is what exactly a collateral warranty is, what you should expect in terms of standard clauses, and the key risks you can find in warranties and how to deal with them. We've got a little QR code on the screen as well, which you can hopefully see, and these slides will be available after the presentation as well, should you wish to go back. This will basically take you to the ECA website. Behind the paywall, there's a legal section, and we have what we call our virtual bookshelf, which you may have heard of before. It basically has an A to Z guide and an A to Z guidance and templates index. Part of that is a collateral warranty guidance note. So basically everything that we talk about will also be covered in the guidance note, which you can go away after the presentation, have a read through. If you have any lingering questions, you can always come back to speak to Rob and myself. But hopefully that guidance note on collateral warranties will provide you with a good framework for what is being discussed today.
So let's start off with the why. Why do you have collateral warranties in the first place, and what are they? So primarily the first bit is privity of contract, a legal phrase which means one thing. You can only sue a party you're in contract with if there's a cock up on the job. Without being in contract with it, you would have to be given a special right under the contract in order to be given the benefit of it. So on screen you've got, if you're in the contract, you have rights and obligations. If you're not in it, unless there's a third party rights clause giving you special permission, you don't have the ability. So as Obaid will explain, in the normal conventional contractual chain, there are parties who are not directly linked to you. Next slide.
Right, okay. Here we have an overview of what you can expect on, let's say, a standard construction project. You've got the purchaser at the top, you've got a client, you've got a main contractor, and let's say you've got an ECA member, the subcontractor. So if you just focus on the left-hand column, in which the contractual chain flows down. Each of those parties is in a direct link with the party immediately below it. So the purchaser is in a contract with the client. The client will have a contract with the main contractor. Let's say the main contractor, for example, was ISG. And then ISG, the main contractor, shall have a contract with yourself, the ECA member, as the subcontractor. Now, the purpose of a collateral warranty is to provide a party that is not directly above you in that contractual chain a means of redress against you or another party in the event that the main contractor, let's say ISG, ceases to exist. They go bust, they go insolvent, and suddenly that red box no longer exists and you've broken that chain, that contractual chain on the left-hand side. So what a collateral warranty does, it is collateral. It sits alongside the primary contracts in a traditional construction chain. So where you see the dotted lines connecting, for example, the subcontractor all the way up to the purchaser and to the client, and also to the tenant on the right-hand side and the funder, those dotted lines are basically collateral warranties. Those are contractual links that are being created between yourself and a party that you are not in a primary contract with. Now, what this does is by creating this link, it gives that other party, who we call the beneficiary, means of relying upon assurances and obligations given within the collateral warranty in order to maintain that contractual contractual link. And as we'll discuss a little bit further, there are certain legal consequences that come of that if you do sign a collateral warranty, which we'll explain and we'll tell you how best to handle them. Next slide, please.
So what we've got, as Obaid explained, is a situation on the right where all the parties at the top that will effectively inherit the finished construction product, i.e. the built asset, want a logbook. They want to know that all the parts of the project as it's progressed and been built are done as they should have been. So that if they sell the asset on, so let's say it's a hotel which will be sold on completion, or high-end residential or something like that, where people have bought off plan before the thing's even been dug into the ground and construction started. Either way, even if it's Westfield in shopping centres, purchaser tenants funders all want to know the assurances that this brand new built product is as it should be. So what happens? Effectively, they want these direct contractual links in case people on the left have gone bust midway through the chain. The rule of thumb used to be you ask for one from anybody who's either done a large chunk of money in terms of the contractual project or a complicated piece of the works. M&E accounts on average for 40% of the cost of any project, and is certainly all the technology that goes inside a building. So invariably, M&E is always asked for collateral warranties. You can also ask for them from subcontractors as well, but as Obaid said, they are secondary documents. Your primary document is your actual subcontract with your contract with your client. What you tend to find in that primary document, if it's a subcontract or even a sub-sub, is that one will dictate your obligations. It might not have anything in, but certainly if you're designing it, invariably it will say, thou shalt give a collateral warranty. But you might go on to say, in the form attached, or a form to be agreed, or a form to be dictated by us. Either way, before you agree to that obligation, make sure you've reviewed the warranty, because once you've agreed to that obligation, especially if it's a form attached or a form that we're going to dictate, you are effectively in breach of your subcontract if you don't sign the warranty. Next slide.
Yeah, so just to pick up on that final point that Rob was making, and we can't stress how critical that point is, that if you're working on a project where as part of the contract package you've been asked to sign a form of collateral warranty, please do investigate and interrogate exactly what that form of collateral warranty is, because as Rob says, once you've entered into the contract, once you signed on the dotted line, you do not at that point have the ability or the leverage to go back and start amending the collateral warranty, and if there are any red flags that are posed at that point, you'll find it a lot more difficult to be able to negotiate with the other side, as opposed to if you do it right away, as soon as you get the package, you ask them what the form of collateral warranty is. So what is the best form of collateral warranty? Lawyers answer there isn't one, but if we're speaking practically on a commercial basis, the gold standard, we will say, is what you will find under the JCT suite of contracts. They have a standard form collateral warranty, and quite often this is used either wholesale or with some minor amendments. If this is the form of if this is the form of collateral warranty which is being used, and then it's a good basis to work off. There's also an option X8, which you find under the NEC. As we've stated, we've got guidance, other organizations have guidance in relation to collateral warranties. The one to be most aware of, again, further to what Rob has said, is if the collateral warranty is in a form to be stated by your main contractor or by a client, especially if they do not follow either a JCT or NEC framework. If they are completely made from the ground up, then who knows what's in them. Proceed with caution. You can still get to a position where you can enter into them, but just make sure that you go through them with a fine comb, because they may throw up a lot of contractual pitfalls that you would not find, for example, in a standard JCT collateral warranty. So always be aware when you see a collateral warranty and you're like, hold on a minute, I've never seen one that looks like this, or this is using terminology or phrases which I've never heard of before. Pump the brakes, go through it, come talk to us if you need to, and then we'll get you to a position where we'll put it in as a compliant position as we can in order for you to proceed. But yeah, the take-home message is make sure that you know what type of collateral warranty you are entering into, and try and avoid bespoke where possible. There will be instances where you can't, but to the extent that you can, try and seek a standard form collateral warranty such as JCT. Next slide, please.
So this is basically the average table of contents of a standard collateral warranty that you're looking for. Anything else, be wary of it. As Obaid said, the bespokes are going to have some bear traps in it. And we'll talk about what those are as we go through. So we're going to dig down and go through these one by one, explain what they are and what to look for in terms of what you don't want to accept. Just to row back slightly, having done this for over 20 years, we can tend to see, and having done it across around 4,000 contractors, we are able to see what is sustainable commercial practice. In other words, what you can and can't get away with. What you do find from lawyers on the other side is they'll say, that's not standard, this is. But they have a very niche audience. They might work specifically within the housing sector or just with consultants or something like that. So by all means, use our guidance note as a reference point for what is usual practice, and throw us under the bus. You can use our guidance note with clients and say, look, that's what I'm being told is normal. What you're giving me is not. Final point there is about consideration. So to make a contract binding, there must be a swap of something of value, usually works for money. This is a collateral contract, so it's not the primary one. The bit where works are being swapped for money is the subcontract that you're working under. They are entered into as deeds. If the deed isn't formally or correctly entered into, the backup is sometimes when you have a line at the top saying, Party A hereby gives Party B £1 or £10, and Party B hereby acknowledges receipt of it. It's a simple legal phrase just to make sure it's all binding in case it's not executed properly. That's all. Next slide.
Right, so one of the most important clauses that you'll deal with in a collateral warranty relates to your duty of care. Now, what is your duty of care? That's basically the standard of care that you owe to another party on a construction project. So normally this will be that you carry out all your works with reasonable skill and care, for example. Now, what you want to make sure with a duty of care clause in a collateral warranty is that you are not giving any further obligations beyond what you have given in your primary subcontract. For example, let's say you've given a duty of care in relation to carrying out works with reasonable skill and care. What you don't want to do in a collateral warranty is go above and beyond that and say, for example, that you will give a duty of care which is fit for purpose, which is a higher standard of care, for example. You want to make sure that it exactly mirrors the remit of your duty of care under your primary subcontract. And also, on that point, don't promise anything in relation to the main works, in relation to the main contract, because unless you've given any obligations under your subcontract, you don't want to get to a position where you, through the back door, if you will, a collateral warranty is asking you to promise more than you would have under your subcontract, where you've priced accordingly to risk and the scope of works. You don't want that to snowball. There's some wording you will see in relation to your duty of care subclause that may include the words has and will. Now, we've used an example there that to the extent that the subcontractor has design responsibility. Now, just to unpack this, what this basically means is, again, coming back to the earlier point, if you have undertaken design responsibility under your primary subcontract, then under this collateral warranty, you will also give design responsibility to the beneficiary of the warranty. What you want to look out for is words that supplant has with will, i.e. the subcontractor will give design responsibility, because then you might be like, well, hold on a minute, I haven't given design responsibility under my primary subcontract. Why will I give design responsibility under the collateral warranty? So again, it's just making sure that you don't overpromise. And it may seem like semantics, but this is those kind of very fine print ways in which a collateral warranty can sometimes trip you up. And just make sure that, again, in relation to duty of care, you don't give any obligations that are greater or for a longer period than under your subcontract, and that any limitations on liability that you have been awarded under your subcontract also apply to you under your collateral warranty. You do not want to give them anything more than what you've been given under your main subcontract. Next slide, please.
So after you promised how you're going to do the works and how you're going to do the design, as Obaid's described, and that you're not going to promise anything more than you promised under the subcontract itself, the next promise you make is simply that you're not going to use deleterious materials. What do we mean by deleterious materials? Well, you're really thinking about things like asbestos. You might now be talking about certain cladding materials, post-Grenfell, or certain others. There is a list of them, usually used to be maintained by the British Council for Aggregates, I think it was, and there is a report by Obaid. So sometimes you see clauses reference those documents, but overarching obligation is I won't use any materials that are deleterious to the project, the durability, the integrity, words like that. What you don't want to do is the promise should be contained to you and yours. In other words, people for which you're responsible for and your team. So if you're using any subcontractors, you take responsibility for them, but you don't want to be promising that you will look out for these things with other contractors on site, because you don't want what we call an inadvertent duty to warn to arise. In other words, you're going to start supervising other people. The other thing you don't want to do when you start to look at the fine print, because trends in drafting have changed over the years. When these started out, you would see that they should be in line with British standards, expanded into European standards. Post-Brexit, that now needs to come back in because we aren't bound by European standards in the same way we were. So generally, you are starting to see the removal of anything referred to as EU. Next slide, please.
Right, so the next hot topic is copyright. Basically, the essence of a collateral warranty is the right for the beneficiary to have the right to use your designs. So all of your designs that you've created will have copyright. What you give to the beneficiary under collateral warranty is what they normally call a non-exclusive license to use your design for the purpose that it is intended. Now, when you're giving this type of copyright license under a collateral warranty to a beneficiary, make sure that this right is given subject to you receiving payment under your subcontract package. This is your leverage, because you can say to them, well, hold on, if I'm not being paid, I don't have to give you a license to use my design, to use my copyright. This is an industry norm in terms of the copyright license being subject to you as a subcontractor having been paid. If you go and look at the JCT standard form collateral warranty that we mentioned before, you'll see it in there. On a practical level, you will often see this being removed from collateral warranties. So this is, again, going back to what Rob was saying earlier, is if you receive pushback, point them towards the JCT and say, hold on, this is a standard subclause within a JCT collateral warranty, on what basis are you looking to remove it? So effectively put the ball in their court, ask them to justify its removal if it has been removed. There's a few other finer points that you need to look out for in relation to your copyright. Is that license, can that be transferred to any other third parties that may be beyond your scope and beyond your visibility? The reason why this is important is you don't necessarily know or have control over how those third parties will use your copyright or your design. So do you want to make sure that any license that you give is with or without liability? And one of the examples that we use on one of the further bullet points is, what exactly is your design being used for on the project? And is that project potentially going to change scope? Are you, for example, designing in relation to an extension or a refurb? Is that design always going to be fit for purpose if it floats from one party to another? Are they going to try and shoehorn it in a way that is not supposed to be used? So in that event, always make sure that if you are giving a license, that you are giving it with a limitation on your liability, and there are express purposes through which your license can be used. Anything beyond that, you won't be held liable for. If you see the words full title guarantee, look to remove them, because again, let's say you've put together a design, you've done the electrotechnical works, there may also be a mechanical aspect which you've inherited from another party. You don't want to give full title guarantee, because that basically means that you are guaranteeing holistically all elements of the design, even if you haven't had any input in its creation. So basically, if you see those words, always look to delete them, because again, you may be exposing yourself to more liability than you should be inheriting. There's a final point where sometimes you will ask to surrender your moral rights. Your moral right is basically your right to be acknowledged as the creator of that copyright, of that design. And often you may see wordings where it asks you to surrender your moral rights, which on a practical and commercial level is usually fine. It doesn't erode away at your rights as the copyright holder. It just means that you may not be identified as the owner of those rights, which may be for commercial reasons if the other party wants to use your design. So if you see the removal of moral rights, that's not necessarily a hill to die upon, but just be aware of what that means. Next slide, please.
So you're starting to see the obligations stack up in quite a logical way. We said this was right at the start with the big diagram with big red box for the main contractor that might have gone bust. And obviously this month it's been ISG. What happens? Purchasers, tenants, funders want to step in and be able to use your design, have your promises that you'll do your work in accordance with your subcontract. You've got your duty of care there, which says we'll do everything we were supposed to do in accordance with the subcontract, in broad terms, followed by we won't use any materials that we shouldn't be using, and then yes, you can use our design, but only if you've paid us. Why would you object to that? Well, you're not going to pay us on time. That won't be a problem. That's going to all be backed up, because there's still a risk you might go bust. So they're looking for your PI insurance as well. PI insurance promise, in simple terms, is going to be you'll take it out, you'll maintain it. They're probably going to be looking for 2, 5, 10, or 20 mil. 20 is very rare because a lot of people can't even get it, and it should be preserved for very highly complicated projects these days. They will look for you to maintain it for either 6 or 12 years post-practical completion. For practical completion of what? It should be your works, but then they'll invariably ask for it to be practical completion of the entire project. But my issue with that is simply, you don't have control over that date. The landscape gardener could hold it up forever and a day. You don't have the right to know when that date happens or have access to that certificate. So in practical terms, it's not a date which you have control or knowledge over. Why would you accept it? I guess it is 50-50 in reality, whether you would get away with moving that back to yours, because as I said at the start, they are looking for an entire logbook suite of warranties that stack up neatly and match each other and all start from PC of the entire project. Second point on insurance is there is usually a slight get out in case the insurance market goes has problems for whatever reason. The get out is your obligation to maintain PI is only there so long as it's available at commercially reasonable rates, not taking into account your own claims record, by the way, but commercially reasonable rates. If they're not available, the party asking for the warranty would have to pay any kind of premium associated with what you can get on the market. And then finally, there's often a kind of clerical clause saying, if we ask for evidence that you've maintained your PI, you will give it to us just in case that's abused in any way. We just tend to ask for a written request that will give the evidence once a year or something like that. I think the extreme cases, they'll put the obligation on you to provide that every year. But if you had to do that across every project with every warranty, there could be thousands. So I would still keep it as at their request. Next slide.
Right, step-in rights. This is basically something that allows the beneficiary to the collateral warranty to step into the shoes of the main contractor should, for example, the main contractor go bust. So using our early example, let's say you're contracting for ISG go bust, there's a gap in that contractual link, and now the main client, let's say, for example, wants to step into the shoes of the main contractor and instruct you directly on the subcontract works. A step-in clause allows the beneficiary exactly that, to step into the shoes of the main contractor. Now, step-in rights by themselves are fine, and they are in place in order to sustain construction projects and ensure that works continue in the event that someone in the middle goes bust. However, there are several things in a collateral warranty that you need to look out for when it comes to step-in rights. Firstly, is be aware of long periods of procrastination, i.e. 28 days. What we mean by this is, let's say your main contractor goes bust. You may find wording in a collateral warranty in relation to step-in rights that says that, okay, if the main contractor goes bust, then we as a beneficiary can wait 28 days before we make a decision on whether we're going to step in and instruct you as the new quasi main contractor. That is a heck of a long time for you as a subcontractor to be sitting around on your hands, having your resources suspended, pending the outcome of the decision, and then catching up on delay. And you may have hired other plant, you may have other labor costs to pay. You don't want to just be sitting around for 28 days and then having that sort of Damocles just floating above your head, where you don't know if you're actually going to continue to be instructed on the project or not. So if you see 28 days, always look to bring that back. Ideal position we would recommend is chop down 28 days to 7 days. And if they push back against 7 days, you can meet them in the middle at potentially 14 days maximum. The reason why you want to ask them for 7 days as opposed to almost an entire month is you may be aware that under construction projects, you have a statutory right, which means this goes above and beyond what a contract may state, is that you have a statutory right to suspend works if you haven't been paid by the final date for payment. You serve a 7-day notice, and if you still haven't been paid at the end of that 7 days, you can suspend all works, you can drop tools, and you can walk away until and unless you get paid. Now, let's say main contractor goes bust, you haven't been paid, you then have to sit around for another 28 days for the beneficiary to make a decision about whether they're going to step in or not. This is where, in that pre-contract negotiation stage, you say to them that, hold on a minute, if you put in 28 days, you are cutting across my statutory right to suspend works for non-payment. So we need to bring this period down all the way to 7 days, ideally. Although if there's a bit of pushing, shoving, you can try and get it to 14 days on balance and say that, look, we as a subcontractor are taking a great deal of risk here, but we need something which is a lot more commercially feasible for us than just sitting around in our hands for almost a month. You also need to ensure that the right to step in is subject to an obligation to pay any outstanding sums and ongoing sums to you. So let's say, again, the main contractor goes bust, you had an interim application in that you were owed circa 50 grand. If a beneficiary is going to step in to the shoes of the main contractor and take control of those subcontract works, they need to give you an obligation that anything that's already owed to you doesn't simply evaporate and go into the ether. They will pay you everything that you are owed, and then they will continue to instruct you. So just make sure that if there is a step in right, then the beneficiary is inheriting all of the payment obligations that your main contractor originally owed to you. And also, as a final point, the main contractor must accept the step in, which basically means they will accept that the beneficiary will step into their place to their express exclusion. And then further down the line, the main contractor won't have any kind of contractual or legal comeback against you as a subcontractor, because at that point, they won't be relevant. To put it bluntly, is you will be dealing with the beneficiary yourself, and you just want to make sure that the main contractor at that point has no legal or contractual entitlement to come after you for anything at all. Next slide, please.
So powers of attorney, you don't usually get them, but I'm going to say 60-40, so 40% of the time maybe you'll see them coming, they're becoming more common, but primarily you don't usually get them. This is really where, so you've got in that generic picture of a construction project, and warranties are being asked for multiple trades, not just you. At the very top, if you're a client's lawyer, you're trying to bag a suite of documents to pass on to the person who's going to purchase, tenant or funder. Certainly funders will want them as security. Power of attorney there is part of leverage. So what you'll find in a subcontract between you and your client is if you don't hand over certain documents at certain points in time, we can withhold money from you. It's what we call a condition precedent clause. Your right to get paid is conditional upon you first giving us documents like tax, insurance, but it also includes collateral warranties. So if you don't get them, we can start to strangle you on the cash flow side. The second way we make sure as a client's lawyer that we get the warranties, because you are in breach of contract by not giving us them, and we've now got the ability to stop paying you under the subcontract, is we'll also say, can we have a power of attorney? So you're giving them the power to enter into documents upon your behalf legally. It's quite dangerous if you think about it, because as Obaid touched on under copyright, and you'll see under assignments, effectively you then don't know who this other party is entering into legally binding relationships with other parties on your behalf. Could be loads of people. So just think about that. I tend to take them out and don't get a lot of pushback on them. I tend to say, no, you can live with the fact that you identify the types of people we should be giving collateral warranties to. We'll agree to the form of the collateral warranty in the first place, and we'll give it if in the subcontract we also want to agree to a clause which says you can withhold money. If we don't do it on time, then fine, but just make it a specific amount of money. So just be very wary, try to object to them. And then the last thing which I wanted to pick up on here, which isn't quite directly relevant to powers of attorney, but it's around this point in the document that you might see some of the more unscrupulous warranties contain a backdoor guarantee of some kind. So primarily, the warranty is there to give the promises we've described. But very occasionally, in a bespoke, you'll see a sneaky backdoor. This is also a parent company guarantee or a director's personal guarantee. Totally unscrupulous, highly odorous, put a line through it, they're trying it on. So that's where we are in terms of power of attorneys, tend to push back, and you don't tend to get a lot of objection about that. Next slide.
Right, so we've got a few more points that we wanted to cover off. The first one, which Rob has just alluded to, is assignment. Now, assignment is basically giving your rights, your contractual rights under that document to someone else. So as the name implies, you assign your rights to someone else. So for example, you may see assignment clauses in a collateral warranty which allows the beneficiary to assign their rights to another party. Now, in principle, that is fine, because especially if you're dealing with, for example, a big client or a funder, there may be a consortium or there may be other subsidiaries that at some point in their commercial lifeline, they may want to assign their rights to in the event of a corporate restructure and so forth. However, what you want to make sure that the number of times that collateral warranty can be assigned is limited. Normally, the standard is 2 occasions only, and that any such assignment is made by notice. So you are informed if the beneficiary is assigning his rights, just so you have visibility as to who exactly is taking on the benefit of that collateral warranty. What you also want to make sure is that the class of businesses, organizations that the collateral warranty can be assigned to is limited to, for example, the purchaser, the funder, and so forth, because you don't want to give an assignment right to just Joe Blogs on the road. You want to make sure that whoever the party is, they have a genuine link to the project, and you're not just, widening your risk exposure just for the sake of it. So just be aware of those. You can always look to negotiate these points, and generally speaking, if assignments are limited to 2 times only, you will find that your risk exposure is a lot lower than, let's say, if there's potentially unlimited assignments. The other point is your limitation period in relation to how long can you be held liable under the works. Now, under your primary subcontract, you may have a limitation period of 12 years from completion of the works. Now, if that is the case, make sure this mirrors exactly what is in the collateral warranty, where you don't want to disconnect. You don't want any kind of disparity where, for example, under your primary subcontract, your limitation period is 12 years from practical completion of the subcontract works. But all of a sudden, in the collateral warranty, you've got wording that says your limitation period is 12 years from practical completion of the main works. Now, there can be a huge time gap between these 2 PCs, because, for example, you may have wrapped up your practical, your subcontract works and left site 5 or 6 months before all of the works under the main contract are completed. So you don't want to give them more than what you've given them, again, under your subcontract. So make sure that the limitation period doesn't go above and beyond any limitation period that you've agreed upon under your subcontract. In terms of making your allocation of risk under the collateral warranty a bit fairer and giving yourself a bit more of a robust defense, there's a couple of other clauses that you can ask for. There's 3 of them, and I'm going to explain what each of them are. And in a commercial negotiation on a practical level, if you can get this first one, net contribution, out of the 3 which I'm going to talk about, it's a winner for you. The other party may think that they've been pretty resilient and they've been pretty kind of commercially astute and maybe able to knock out 2 of the 3 that you've asked for. But if you get one of them, it is practically a winner for you, and I'll explain why. The first one is a net contribution clause. What this basically means is that if there's potential breach on a project, or if there's potential damages that flow out of a breach, then you will only be liable for the percentage of that breach that you can be held accountable for. For example, there may be other contractors, there may be other subbies on site. You've done electrotechnical work, someone else has done mechanical work, someone else has done mechanical works. Let's say there's a breach, and you are only 50% responsible for that breach. Mechanical did something else, and they have to take on 50% of that liability. What a net contribution clause basically does is that it ensures that you are only liable for the act or omission to the percentage that you caused that breach. So let's say it was 50%. So you won't be 100% liable for a breach that was beyond your control. So again, it's just limiting your exposure, it's limiting your liability. So we always look for our members to seek a net contribution clause. So again, you aren't over promising anything, and that you aren't being held liable for any harm or any damage which is being caused by someone who is not within your control or your remit. The other subclause that you may see sometimes that we would ask for is an evaporation clause. What an evaporation clause basically means is that the limit of your liability will mirror the limit of your liability under your insurance. If it goes above and beyond whatever your insurance coverage states you are protected by, your liability effectively evaporates. You won't be liable for anything more than what you've been insured for. The third one is a limitation of value. So again, you will see this in collateral warranties where it may state that you will only be liable for 100% of the value of the subcontract works, or potentially 150%. Where possible, obviously try and seek 100% so it aligns exactly with the subcontract works. Again, it's another mechanism by which you can look to reduce your exposure and your cost liability. So again, but there's three that we look for: net contribution, evaporation, the limitation by value. The one that we would put the most importance on is net contribution. If you get the other two, brilliant. If you don't and you get net contribution, that is, excuse the pun, a net win for you. The final point is third-party rights clauses. As we explained at the very beginning, you've got privity of contract, and when you give a collateral warranty, you are creating a contractual link with a beneficiary. What you basically want to do is exclude the rights of third parties to basically come in and have any rights or any control under that collateral warranty. So you effectively want to exclude the rights of any third party in relation to that collateral warranty, just so you know exactly who the parties are that have any contractual remit and recourse under that legal document, i.e. the collateral warranty. Next slide, please.
So we're getting to the end of it now, where you're getting to the window dressing clauses, what we would call, these are just standard boilerplates. Notices you will usually see, as Obaid's discussed, around copyright and insurance and other things, that certain things might need a notice from one party to the other. This will just set out how they are to be given and when they are deemed to be received. Usually you can do it by hand or by post, but you might want to think about, do you want it to be recorded delivery, so there's proof of receipt, then you don't get silly arguments about, sorry, never received that. You might want to consider, can you do it by email? Some companies reject that because they regard all inboxes personal and not necessarily monitored if there's sickness or absence. Others are perfectly fine with email because they have centralized inboxes that are automatically forwarded on to others and therefore constantly monitored. In terms of disputes, recent decision from the courts said because collateral warranties are secondary documents, or they are ancillary to the primary subcontract where you're actually doing the works, the warranty itself isn't a contract for the works, and therefore it's not within the Construction Act, give it its full name, the Housing Grants Construction Regeneration Act, that brings in adjudication as a means of disputes resolution. So in other words, warranties don't automatically get you adjudication. If you like adjudication, or you want it because it is quicker and cheaper than courts, and certainly quicker and cheaper than arbitration, you can contract into it. You could insert some lines, and you could specifically refer to the low value adjudication system, which is going to be more cost proportionate for you, whereby if there is a dispute under the warranty, either party could refer it to adjudication, which is quicker and cheaper. Remember, it's a 28-day process. And then the final point about law and jurisdiction is you do want it to say this agreement is subject to the laws of England and Wales and the exclusive jurisdiction of the English courts, which just means if the project was somewhere else or if one of the other parties was overseas, you're not going to have a side argument about whether you should be arguing this under their laws of their country or suing them in their courts. So it keeps any legal costs down as well. Next slide.
Right, so we're approaching the end of us talking at you, and in a moment we're going to open up to you in case you have any questions, but just wanted to kind of pull back for a moment, give you a summary of what we've discussed this morning. So to state the obvious, check your obligations to give collateral warranties under a subcontract package. Some of them will entail that you have to enter into a collateral warranty. Some of them will say that you do not. So before you commence works, before you enter into a subcontract, before you sign on a dotted line, go through the package, see what you need to do. Do you need to give a collateral warranty? And if you do need to give a collateral warranty, what is the form of that collateral warranty? Again, check this before you enter into the subcontract. So if any of the pitfalls that we've discussed today do manifest in that collateral warranty, you want a position to negotiate and amend that collateral warranty before you enter into the subcontract. You can always cross-refer every clause within a collateral warranty against what we've put in the ECA guidance note, which again builds upon everything that we have discussed this morning. So you can basically have two documents next to each other, side by side, cross-refer and say, okay, well, this is what I need in relation to duty of care. This is what I need in relation to a contribution clause. Have I got this in my warranty? Yes, tick. If I don't, okay, I'm going to flag this and I'm going to go back to the other side and ask them to incorporate it. And yeah, to that point, fight hard for a net contribution clause, because that we believe is to be one of the best mechanisms by which you can limit your liability under a collateral warranty. Also, always remember that a collateral warranty is secondary to your subcontract, and you should not be over promising. Do not extend your liability any further than the liability that you have given under the subcontract. So make sure that there's no backdoor way by which you are being held accountable for more than you should under your subcontract. If the form of the collateral warranty itself is different to the JCT, again, proceed with caution. Push back on points which you think are non-kosher and that need to change, and then be prepared to hold your ground, because as Rob was saying earlier, you may have certain parties on the other side, you may have certain lawyers that will say, well, you know, this is industry standard, but maybe industry standard for them in their particular niche, but it's not necessarily industry standard for you. And that's again why we referred to the JCT collateral warranty earlier as a bit of a gold standard. It is the standard form they can always go back to. So even if your form of collateral warranty isn't a JCT, you can refer to that and say, look, this is what the industry norm is. If you're going to deviate from this, you need to justify why you're deviating. And ultimately, we are here for you. We will help you establish what your perimeters are, commercially speaking, contractually speaking, and we will help you evaluate what you can and cannot accept under a collateral warranty, because there may be some instances where you're not sure. And in those instances, you can always come and just, you know, just speak to us and say, okay, well, Rob and Obaid, I've got this point in the collateral warranty. I'm not sure if this is something I should be agreeing to. What do you guys think? So together, we can inform, we can educate, we can support, we can advise, we can put you in a position where when you do finally enter into that subcontract package, you are going into it with both eyes open and you know exactly what you can and cannot do and exactly what you have promised. So again, we hope you found this useful. Again, if there's any questions, I'm just going to hand over to Rob and he will lead on the Q&A session.
So up on the slide there, you've got our centralized inbox. It's obviously worth emailing us. It gets logged our end and we take each inquiry as it comes in. Be aware that if there's a big queue of members, we might take a little longer than instantaneous to come back to you, but we will work through them. Invariably, our inquiries always start off with, look, well, we need to see the documents before we can advise, which is why we give you an inbox rather than a number. Omar, is there any questions that have come through whilst we've been presenting?
Yes, Rob. So before we jump into those, I just want to say thank you to you both for that presentation. A huge amount of super valuable information there. Just like to remind our viewers that a full replay of today's session will be available in the members area of the website, so you'll need to log in to view that. That will also include access to today's slides. As Rob and Obaid mentioned, there's been a QR code up on screen at several points throughout today's webinar. Don't worry if you haven't been able to scan that. The replay will be available on the members area. And for everyone who's watching us today, who's attended the live webinar, in about an hour's time, you will receive an email with the link to your ECA Professional Development Certificate that you will be able to log against this webinar. So, Rob, Question for you before we launch into the Q&A.
Yep.
Well, question I could put to you both actually. Huge amount of information today. If there was one bit of information that you could pick out from today's slides for our viewers to take away, what would it be?
Mine will be either net contribution or step in, really. I'll start with the net contribution. As Obaid described, you can go in hard. If somebody doesn't have one in, the point you've got to take away is you could have subcontractor A, B, and C, all given collateral warranties. Building burns down. Who's to blame? Okay, it could be all of you to some degree. A's 50%, B's 25%, C is 25% to blame. What happens is the law says the person suffering the loss can sue any of A, B, or C for all of the loss. And if A's gone bust, B and C have to pick up that 50% between them. That's really harsh. You're also, your PI insurance is only, or your insurance is only going to cover you for loss which you actually caused, not going to cover you for loss caused by others. So the net contribution is vital because it comes in, it's standard, because as Obaid said, it's in JCTs. And it simply says, well, I'll only be liable for the loss that I caused. So if I'm only 25% to blame, that's all I'm covering as per my insurance. So that's your one key takeaway from me.
Dave, would you like to add to that? Or?
Yeah, so I think I'm going to harp on about not over-promising. Again, just if we bring it back to limitation of liability, make sure that you are not giving any representations that you are going to go above and beyond what you've agreed under the subcontract. So bring it back, duty of care, make sure that the standard of care which you have given under the subcontract, which normally is reasonable skill and care, is exactly the same under the collateral warranty. You aren't giving them a higher duty of care, such as fitness for purpose. For example, also your limitation of liability, like we were discussing earlier, if it's linked to the subcontract works, completion of the same, then make sure that under the collateral warranty, they haven't just put some generic wording that says that your limitation of liability starts from the end of the completion of the main contract works, because again, there may be a massive disparity between the two, and you don't want to be on the hook for longer than you need to be. So yeah, just make sure that there's nothing coming into the collateral warranty which is widening your exposure, because there's obviously practical repercussions, there's commercial repercussions, and also you would have priced your subcontract works taking into account certain risks. You can't have priced for something which you would not have seen as a risk. So just make sure that that collateral warranty through the back door isn't bringing any unpriced risk into your project.
Okay, thank you. We've got a few minutes to cover some audience questions. We may overrun slightly, so I apologise for that. In the event that you're not able to stay on past 10 o'clock and we don't get to your question today, we have your email addresses, so we will be able to get back to you after this webinar. So we will get around to your questions eventually, one way or another. So a few of these relate to particular slides, so I will do a bit of scrolling back. Our first question here relates to the duty of care slide. So I'll just quickly make my way back to that one. So there was mention of £1. And the question is, does the £1 actually have to be invoiced and evidenced?
No, simple as that. It's a notional, what they used to call in law school peppercorn, to make the contract binding. So some people put it up to £10 now, but that's why the sentence is, I give you £10, you acknowledge that you've been given the £10. Nobody ever needs to be given it. I have seen somebody walk into a meeting for comedy effect and put a tenner on the table and say, there you go, but no.
Okay, thank you. So the next one was linked to the insurance slide. Here we are. The question is, can we kick back on the PI insurance requested, even if we have the 20 million?
Even if you have, sorry, what?
The 20 million.
Yes, you can. 20 mil was something we saw post Grenfell and certainly through COVID. I haven't seen an awful lot of members actually report back that they've been able to get it, or where they have been able to get it, it's been for a specific project. So the insurers have said, well, we'll give you it for that project and based on this premium. And because your clients asked for it, the other thing they've turned around and done is say, you want it, you pay for it. We've got 5 or 10. If you want 20, we are able to get it. We've spoken to our brokers, etc. But here's the charge for it. So that's your premium for asking for a ridiculous level of cover. So put your money where your mouth is what I would say on that. Types of cover is a different question, but in terms of the financial level, yes.
Right. This next question here may or may not be linked to the step-in or power of attorney slides potentially, or it may be unrelated. Question is, where do you stand if you only received a purchase order or order number against a quotation for the works as an appointment and are then asked to provide a collateral warranty? Does this present more or less risk?
Obaid, do you want to take that?
Yeah, there is an argument to be made, and I'll throw this back in a minute to Rob as well to get his views on it, is that you're bound by what you sign at the beginning of the project. Now, the thing to really investigate is when you are sent a contract package, there's 2 outcomes that can potentially come, and taking your example. One is that there is no collateral warranty part of the package and you're not asked to enter into one. And then if that is the case, further down the line, if they suddenly manifest one, you can say to them, well, on what basis are you asking me to enter into a collateral warranty? This was not part of the agreed terms between the parties, and no, it was not a condition precedent to payment either. So no, we're not going to enter into a collateral warranty at this point. But the other situation, which sometimes is more common, is that in the contract package, it'll make reference to a collateral warranty. And in your subcontract, it may also say that if you haven't signed a collateral warranty within X amount of days, then we are entitled to withhold payment to you. What sometimes happens is it makes reference to all of this, but then you're not sent a collateral warranty until often the back end of a project, where suddenly someone wakes up and goes, shit, we were supposed to have all these security documents signed by all of the subbies. Let's send them out and let's get them to enter into a collateral warranty. That is bad commercial and business practice, but that is a scenario where technically the parties should have entered into a collateral warranty. And there may be a case that your main contractor or client can then make, even at the 11th hour, to say to you, well, if you don't sign this collateral warranty now, we aren't going to make final payment to you. Let's say you've got a couple of interim payments to go. That is a slightly different situation. And in that instance, subject obviously to your specific requirements in that project, we can look at that collateral warranty. And on balance, we can tell you that, okay, this is procedurally improper, but at this stage, I think you are okay to enter into a collateral warranty. Whereas if it's a case where you've just been sent a purchase order, there's been no mention of a collateral warranty, it's a lot more difficult for them at that point to kind of reverse engineer a situation and force you to sign a collateral warranty. Any views on that, Rob?
I would, yeah, if there's no requirement in your purchase order to enter into it, and bear in mind your purchase order might reference other terms and conditions you haven't seen or been given. But once you've established there isn't a requirement, you don't need to give it. Simple as that. You could even turn around, and I have seen this done, and say, well, we will give it, but it will cost you $5,000. And then you put them to the test to see whether they really, really want it. As Obaid said, if you're required to give one, they haven't said specified form or whatever else, and they send you one and say, that's it, give us it back in 14 days or else you're in breach and we'll withhold money. Amend it, send it back, sign it and send it back. Because if the obligation in the subcontract doesn't say it must be in the form we give you, then you don't have to accept the form they're giving you. So that's why the kind of link across to the subcontract is so important. Any others, Omar?
Thanks very much, both. We've come up to the hour. We'll squeeze in just one last question, But like I said, there have been quite a few questions today, so we will get back to you by email for those of you who we haven't been able to answer questions today. So last question before we log off this morning. Should we be concerned if we are being asked for a collateral warranty when we don't have design responsibility, but say a nominated subcontractor has design responsibility for their works?
So I think you are describing, you have been, let's say, slightly controversially, electrical comes out from main contractor to you, the ECA member, and you have been told which foreign security contractor to use underneath you. So, in other words, not nominated in the old-fashioned JCT, they have contractually specified them, but they are told you who you are going to be using and not giving you much choice in it. You are free to push back, but you'll probably lose the job. Can you push back on that? Yes. What you might want to do is make sure that in your subcontract with this subcontractor, you get them to give a collateral warranty as well. If you are getting them to do the design of, let's say, the fire and security system as part of your electrical package, you do have responsibility for their design. Because in your subcontract with your client, you're taking responsibility for the whole thing. You just happen to have subbed it out. If you weren't doing it and it was a totally different trade which you weren't responsible for, then you would be in the position of saying that one line that Obaid mentioned under duty of care, which is we take responsibility for the design to the extent that we have actually designed it. And we all know that quite commonly in subcontracts, you get dumped on with this design development responsibility, where a consultant might have done the first pass at design and then you're asked to develop it. And so again, you're tying it in with your provisions of the subcontract itself. I hope that helps, but by all means, you've got our contact details, email us in and we can expand on that.
Okay, we will wrap up there for the morning. Thank you very much to all our viewers today for joining us. And thank you, of course, to Rob and Obaid for that fantastic presentation. Like I mentioned, in about an hour's time, keep an eye on your inboxes. May or may not go to spam, so just be aware of that. You'll receive a link to your professional development certificate, and there'll be some links to the replay of this webinar that will be available most likely by Monday, so in a couple of days' time. Thank you very much, everyone, and have a great rest of your day.
Thank you.
Yes, thank you.